So thank you for joining us, Professor Mark Lendley. We're going to talk about the Rocky Mountain IP Institute. Can you tell me what keeps you coming back year after year?
So this is a program that really has done a remarkable job of drawing not only top speakers, but top attendees. There are hundreds of people who come every year. It's been growing every year. And I think that's because every year there's top quality programming. People learn an enormous amount. You hear from some of the leaders in the field. And so I love coming back, not only to present and get good feedback from my audience, but to hear everybody else talk as well.
So this year we're focused on AI and big data and driverless cars as kind of topics and themes. Can you talk a little bit about some of those topics and what we might expect to hear?
Yeah, there's a lot of going on in the law of AI, and so some of it has nothing to do with intellectual property law, but it's still, I think, important from a technology law perspective, right? So, we're in the process of trying to figure out what happens when self-driving cars make unexpected decisions and kill somebody. That's already happened, right? And we've got a tort system that we've built around the idea that humans are drivers, and so the question is, are they negligent, right? How much attention were they paying? What's their mental state? None of those questions seem to make a lot of sense if we're asking the question of a car, right? We might want to think about this in terms of products liability, although even there, one of the problems with artificial intelligence is increasingly machine learning systems are going to do things not because they were poorly designed, but for reasons we don't understand. Maybe it was a flaw in the algorithm. Maybe it was you didn't train it properly. Maybe it was you used a bad set of training data. Maybe it was the user kind of gave it instructions that were inappropriate. But we're going to try to figure all that out.
Yeah. But it's not like debugging like one program anymore. It's debugging not just the programs and the algorithms. It's going back and debugging what the data is doing itself as well.
Yeah, and try, right, exactly. And that means two things. I think one thing it means is we often won't understand why something did what it did. So my favorite story about this is a group of scientists who are trying to train self-flying drones to sort of, locate themselves and fly to the middle of a circle. And they use a machine learning algorithm, and the drones are getting better and better. And then all of a sudden, they get much worse. And the drone will sort of turn away from the middle of the circle and fly directly out of the circle. And they were just puzzled what was going on, what had happened, and eventually figured out that because this was a training program, the drone had learned that if it flew outside the circle, what happened was it was turned off, and then from its perspective, somebody went over and picked it up and carried it back to the middle. So it was magically teleported to the middle of the circle. And it had reasoned that the quickest way to get to the middle of the circle, if I'm all the way over here, is go to the edge of the circle and then be magically teleported and turned back on in the middle of the circle. So it did exactly what we asked it to do. It just did it the opposite of what we wanted it to do. And I think one of the problems that we're going to find is that problem, right? That's really hard to unravel. So we don't understand why the car did what it did. We could just say, well, add a line of code that says don't swerve left in this situation. But since we don't understand why it did it, we don't know what the consequences of doing that would be, right? And it might screw up a bunch of other things in ways we can't predict.
Right. But when we teach it that the shortest path is the way that it should go, then it's going to take the shortest path, whether that's what we want it to do or not, kind of like kids.
Yes. And so actually, the analogy I use is, any story that involves a genie and 3 wishes, right? The moral of all of those stories is the genie will do exactly what you ask. So be very, very careful what you ask it to do. And I think AI is like our genie, right? It could give us enormous benefits, but it could also do something really bad, not because it sort of was programmed wrong, but because we didn't specify exactly what it is we wanted it to do.
Right. So let's talk a little bit about the Supreme Court, because that's always my favorite part of your talks. But let's talk a little bit about them, because they're not doing much on the patent side this year.
Yeah, so the Supreme Court last year had a bunch of patent cases. They've had a number of patent cases for several years. This year, the patent cases they've got, frankly, aren't that interesting, but they're outweighed by the most interesting year that I can remember for copyright and trademark law. So we've got 8 IP cases at the Supreme Court this year. Just for comparison, that is about 13% of their total docket of all kinds of cases or IP cases this year. And that includes some really fascinating and important copyright and trademark cases. I'll just mention a couple. The big one, I think, that everyone's watching on the copyright side is Google versus Oracle. This is both the first time that the Supreme Court has ever dealt with software copyright, to what extent interfaces and program modules are copyrightable. It is also the first time in 25 years that they've dealt with the fair use doctrine. And so there's a huge amount of money at stake, but I think there's a lot more than that at stake. The whole way that the software industry has developed could change if the Supreme Court affirms the Federal Circuit and says, nope, sorry, you can't just re-implement somebody's application's program interfaces to make your program compatible with theirs. That would fundamentally change the nature of the software industry.
Mm-hmm.
Other cases we've got that are interesting, the Public Resource versus Georgia case presents the question of whether the law is copyrightable, and if so, what is the law? PublicResource.org is a group that has tried to make the law freely available, and they have included in that the official Georgia annotated code, which is the only actual print source of the law of Georgia, but which also includes annotations that were written by a private company. And so the question of whether those things are copyrightable, whether the state can prevent people from copying these sort of things that are adjunct to their statutes, I think is a really interesting one.
I'm fascinated by it. I can't wait to see what the Supremes do about that.
And so the final copyright case I'll note is we have our first ever true copyright piracy case. That is a copyright case involving pirates. This is a case in which the relevant copyrighted work is the video of the discovery and salvage of the Blackbeard pirate ship off the coast of North Carolina. And the state used it and is claiming sovereign immunity. And there is at least some indication the Supreme Court may be willing to reverse course and take away sovereign immunity for states when it comes to copyright infringement.
So lots of things happening at the Supremes. You are also going to be talking with Director Iancu, who's coming back to the Rocky Mountain IP Institute for the second year in a row. I'm super happy about that. Always love spending time with my boss. But what do you think you're going to talk to the director about?
Well, it's always a bit of a challenge to know, because the world of patent law is rapidly changing. But I think some of the things that a lot of people are thinking about involve the changes to the PTAB. Starting, I guess, with the question of whether the PTAB is legal at all, which is currently in a matter of some flux, but also a number of changes that the director has made to the process, to when and how you can amend claims in PTAB, to the rules regarding real parties in interest and the filing of multiple claims. So I think there's a lot going on there. I think the PTO's patentable subject matter guidance has been drawing a lot of attention. One of the things that's interesting about it is it seems to diverge a fair bit from the Federal Circuit case law. So we might be seeing the patent examination process and the court litigation process moving in somewhat different directions. And what happens there. And I think that's particularly important now that the Supreme Court seems to have told us that it's done with patentable subject matter. The patent owners and the patent office made a very strong play to get the Athena case taken. It seemed like all the stars were going to align for this, and the court showed no interest in it. So I think going forward, the Patent Office and the Federal Circuit are going to have pretty primary roles to play in figuring out how patentable subject matter law gets worked out.